My name is Kane Tatlow, but that doesn't matter for this story. What matters is a strip of land, 2 acres, that my grandfather bought in 1971, long before Maple Hollow Estates existed. Long before there was an HOA, a clubhouse, or a community park. When developers built the neighborhood around his land in the 90s, he refused to sell. He fenced it off, paid his taxes every year, and left it to my mother, who left it to me. I never built on it. I never needed to. It sat there, quiet, at the edge of what is now called Hollow Park, the crown jewel of Maple Hollow, according to the HOA newsletter. That's why the letter confused me. It came from the Maple Hollow Homeowners Association, informing me that I was in violation of community bylaws for unauthorized structures on association property, and had 30 days to vacate. From land my family had owned for over 50 years. I climbed over it anyway. It was my land. I drove out that weekend to check on the land myself. I hadn't been out there in almost a year, no reason to, it was just trees and a rusted gate. Except now there was a brand new chain-link fence running straight through the middle of my property, and a sign bolted to a post, "No trespassing, Maple Hollow HOA property." I climbed over it anyway. It was my land. That's when I noticed the ground. Fresh gravel. I brought a printout of the letter to the HOA office. The board president, a man named Gerald Kowalski, met me with a smile that didn't reach his eyes.
"That parcel has belonged to the association since 1994, he said. "You'll find the paperwork is quite clear."
"Show me," I said. He couldn't. Not that day. He promised to have it pulled from the archive. I left with a business card and a bad feeling I couldn't shake. The next morning I drove to the county recorder's office. I already had my copy of the deed, the original, signed in 1971, notarized, recorded, and reconfirmed when the property passed to my mother and then to me. Clean chain of title. No liens. No transfers. No sale to any homeowners association, ever. I asked the clerk to search for any HOA claim on the parcel. She typed for a long minute, frowned, and turned the screen toward me.
"There's nothing here," she said. "No deed, no easement, no annexation record. As far as the county is concerned, that land has only ever had one owner, you."
That night, someone left a note wedged in my door. No signature. Just 7 typed words. Drop the property claim. Some things stay buried. I stood on my porch a long time, reading it over and over. Buried. Not abandoned. Not forgotten. Buried, like it was a choice of words meant for something specific. I thought about the humming vent under the oak trees. I mentioned the fence to my neighbor, Ruth, who'd lived in Maple Hollow since it broke ground. She got quiet.
"There was construction out there a few years back," she said. "Big trucks at night, always past midnight. The board told us it was a storm drainage project. Nobody ever saw a drain. She hadn't thought much of it until now. You should be careful," she added. "Gerald doesn't like being questioned."
A second letter arrived, certified this time. Final notice of violation. The HOA was now threatening a lien on my home, not just the land, claiming unpaid assessments tied to the disputed parcel, and warning of legal action if I didn't sign over quiet title within 2 weeks. They wanted me to sign away land I'd never agreed to give up, to make a problem disappear before anyone asked why. I called a lawyer that afternoon. Her name was Andrea Voss, a property attorney who dealt with HOA overreach before. I laid out everything: the original deed, the county's blank search results, the fence, the vent, the notes.
She read the deed twice. "This is airtight," she said. "Recorded, unbroken chain of title, no competing claim on file anywhere. If they try to take this to court, they have to produce their own deed. And you just told me the county has nothing."
"So what do they have?" I asked.
"Apparently," she said, "a fence and a threat."
We filed first, a quiet title action, asking the court to formally confirm what the county records already showed: the land was mine, free and clear, and the HOA's claim of ownership had no legal basis whatsoever. Filing first mattered. It meant the HOA could no longer quietly bully me into signing something in a back office. Now their claim would have to survive daylight. Gerald Kowalski was served 3 days later. Ruth told me his face went the color of the gravel behind the fence. Before the hearing, I went back to the property one more time, legally, since it was still mine no matter what any fence said. I brought a flashlight and my phone, recording everything. The vent wasn't the only thing out there. Half hidden under a tarp near the tree line was a steel hatch, industrial grade, with a keypad lock bolted into fresh concrete. This wasn't drainage. This wasn't landscaping equipment. Something had been built under that park, quietly, expensively, and entirely off the books. I didn't touch the hatch. I didn't need to. I had enough. The hearing opened with the HOA's attorney claiming the association had informally administered the parcel for decades and intended to formalize ownership in due course. Andrea presented my case plainly. The original 1971 deed. The unbroken chain of title through my mother to me. The county's certified search showing 0 competing claims. Tax records, paid in full, every single year, in my family's name.
There is no ambiguity here, she told the court. My client holds the only valid deed to this parcel. The association has produced no documentation of ownership because none exists.
The HOA's attorney had nothing to counter it with. Not one page. Under questioning, Gerald was asked directly, what was built under the park, and why was it fenced off from the very homeowners whose dues had apparently funded it? He tried to dodge. The judge did not let him. Eventually, he admitted it. Years earlier, a small group on the board, without a vote, without disclosure, had diverted association reserve funds into building an underground storm shelter and storage structure, marketed to no one, disclosed to no one, built partly on association land and partly, unknowingly, onto a 2-acre parcel the board never actually owned. When they realized their mistake, instead of admitting it, they tried to quietly pressure the rightful owner off the record. The courtroom went very quiet. The judge's ruling took less than 5 minutes to deliver. Full and clear title to the parcel was confirmed in my name. The HOA's fence, structure, and any improvements on my land were ordered removed at the association's expense, or transferred to me by agreement if I chose to keep them. The threatened lien on my home was voided. And the judge referred the matter of the undisclosed spending and secret construction to the State Attorney General's office for further review, along with a note recommending an independent audit of the HOA's finances. Gerald Kowalski did not look at me on his way out of the courtroom. 6 months later, the fence is gone. The hatch is sealed and inspected. The rest of the homeowners, the ones who'd been paying dues into a structure they never knew existed, got their own answers, and a new board got elected soon after. As for my land, it's still mine. Same as it was in 1971. Same as it'll be when I pass it on someday. I didn't win because I was clever, or lucky, or loud. I won because a piece of paper my grandfather filed more than 50 years ago said exactly what it needed to say, and no amount of fences, letters, or threats could change what was written on it. Some things really do stay buried, until someone finally has the deed to dig them back up.